Number E001 of 2021, Muslims for Human Rights versus Independent Electoral and Boundaries Commission, Speaker of the Senate and Speaker of the National Assembly.
Myron, good morning.
Morning. Who are you?
My name is Kituku.
Yes.
Kituku. I appear for the petitioners.
Yes.
Yes, please, my lord.
Yes.
I am Monkey. I appear together with Arnold Chen. We appear for the proposed interested party, building bridges to a united Kenya National Secretariat.
Zamani, how are you?
Right, thank you, my lord.
It's a pleasure to see you after a long time.
It's a pleasure to, my lord.
You appear with Mr. Ochieng.
Ochieng, Arnold Ochieng.
Yes, my lord, I'm present.
You have our respondents.
For the proposed interested party, which is the Building Bridges National Secretariat.
Myron, what's coming before you this morning is the petitioner's applicant application.
We only have two parties.
Yes, I was explaining that we did serve the application and the petition on all the respondents, and we have filed an affidavit of service to that effect. As to why they are not in court, I would not know.
Your petition is dated.
The petition is dated the 31st of December 2020 and filed in court on the 4th of January 2021.
The respondents are not in court.
Yes, and they have not entered any appearance to the best of my knowledge.
So how did the interested party get to know about these proceedings? The proposed interested party.
My lord, there have been quite a number of cases, many of which are in Nairobi, that have affecting the proposed interested party. So we have been keeping track of this case. It started off with a demand that was made to IEBC, and then we were therefore aware that it was most likely going to turn into a litigation. So we were able to know immediately it was put in.
Yes, Myron, and to add on that, I think the petition and the application were in the media. They were broadcasted widely in the media, in both print and electronic and social media. So, and we still served the respondents with the petition and the application, and we have returned service to the court. What is coming before you is our application dated the 31st of December 2020, filed in court on the 4th of January 2021, as well as the interested parties application.
These are applications in January 2021.
Yes, in January 2021. In public interest, yes, proceeding.
In instance, your application has not been opposed up to now.
Exactly, and they have not entered the appearance, my lord. And the interested party cannot purport to respond on the issues in the petition on behalf of the first respondent, who is the constitutional body that has been mandated with the powers to certify and verify the signatures that have been collected by the interested party in accordance with Article 257, 4, and 5 of the Constitution. And in any event, my lords, we are not opposing the interested party's application on prayer 2 on the issue of their gender.
My lord, may I propose that maybe if there is no objection to our being joined, that order must be made so that we could formally be heard on the other issue that my Canada to raise about her application.
How quick prayers their solar application have this month?
Our application is just, sorry, below. This is the notice of motion, which is on page 17. It seeks to first have the building bridges joined as an interested party, but we are also alerting to the fact that there are several matters of a similar nature that have been consolidated before a 5-judge bench in Nairobi, and that they are raising largely similar issues, and that in one of those cases, similar orders as the one being sought before your lordship have been sought and denied in Nairobi. That we wish to raise that once we dispense with the issue of joining.
Madam, just for clarity, as I said, we are not opposing the first interested party's application insofar as the application for joint is concerned. We will only be opposing prayer 3, which in our view is incompetent and incapable of being granted by this court. So, Madam, if you allow me, I would propose that we start with our application for a conservatory order. Thereafter, we revert to the interested parties application on the issue of transfer and consolidation of the petition with the other petitions such as before a 5-judge bench in Nairobi.
I can still think that we cannot join as a respondent if there's no respondent in these proceedings.
We were not aware that it was going to go the way it has gone, that the respondents were not going to respond, but we would be happy to be full respondents in this case. In fact, my lord, we have accused the petitioner of deliberately leaving us out of this case while the orders that are being sought are affecting the proposed interested party. Now, it does not affect us directly, any of the other respondents. The exercise that is being challenged is an exercise that is being conducted by the proposed interested party. So we are the ones who suffer the most in this case. We would be very happy to be joined into this matter as full respondents.
My Lord, the petition challenges the mandate of the first respondent and the second and the third respondents insofar as their functions are concerned under Article 254, 257, 4, and 5 of the Constitution. To that extent, our petition is the proper respondents in our petition are those bodies that are constitutionally mandated to perform those functions. The first interested party, the BBI Secretariat, is not the body that is charged with the exercise, with the power to certify and verify the signatures which has collected for a popular initiative to amend the Constitution. Number 2, my Lord, the interested party is not the body that is well mandated to enact laws in Kenya that will provide a regulatory framework for purposes of Article 257 of the Constitution. Their only interest in the petition can only be that they would be affected by the outcome of the petition, and to such extent they are properly so, and they properly sought themselves to be an interested party, but not respondents. They can therefore not purport to respond to the petition on behalf of the constitutionally mandated bodies. Those bodies ought to come to this court to explain to us how they are undertaking the mandate under
come to court to explain to you and to court what they are doing. However, this is a public interest issue.
Yes.
And the court cannot just take it on the face value that a party has refused to come, and therefore the court proceeds just like that. The court has the mandate, supposing, for example, that this party refused to come, the court has the mandate at the time of joining a party. The court can decide that I'm joining as an interested party, or I will join you as a participant, depending on the state. The court also has a right and a duty to compel a party to enter appearance and file their defense. And therefore, what I think I should do in this matter is to compel the respondents to enter appearance and file their defense because it's a public matter. They are not going to tell me that they are not coming to court and therefore the matter is not defended and then give orders. It can't happen in a public litigation like this.
Very well, my Lord. We are agreeable to that suggestion. However, then we would suggest the orders being issued to compel them to attend court, and for them to come to court, there is need for this court to preserve the subject matter and ensure that the subject matter is in situ, so that the proceedings of this court and the petition are not rendered negatory. And my Lord, by that I mean that we would therefore ask the court to give us a conservatory orders as prayed in prayer 2 of our application, pending the respondents framing the matter and providing further responses to our application and adjudication of the application.
Okay, let me make a necessary order first before you go.
Thank you.
Following the submissions from both parties, that the application by the proposed applicant in terms of joint adherence proposed, I have joined the proposed interested party, building bridges to a United Nations Secretariat as an interested party to these proceedings. So the other substantive application, other substantive in that application is one which is opposed, or which will have to submit upon. Now I can listen to what you are trying to say is to.
Thank you, my Lord. We are obliged to that extent. Now, my Lord, my submission is that we are very well aware that this matter has been filed on public interest nature, and because of the public interest nature involved, it would only be prudent to have the respondents, as you have, my Lord, as you have highly on guided, then appear in the matter. However, as that is pending, my Lord, we are aggrieved because the actions being undertaken by the first respondent are a continuous violation of the Constitution, Article 10 of the Constitution, as well as Article 257 of the Constitution. To that extent, therefore, we know that that exercise has been undertaken with resources by the people of Kenya, and Article 201 of the Constitution mandates or obliges every state organ and every state office to prudently use their resources. To that extent, therefore, we would ask the court to issue a conservatory order that would be in terms of prayer 2 of our application, stopping the first respondent from continuing with the verification exercise required under Article 254 of the Constitution. If this exercise is not continued, is not stopped and it continues, and the first respondent certifies that the signatures it received have complied with Article 257 for the Constitution, then the petition will be rendered nugatory, because the next step would be for the first respondent to forward the Constitution of Kenya Amendment Bill 2020 to the county assemblies. In the very end, this court will not be having its constitutional power under Article 165 to adjudicate over the issues in the petition, because the subject matter of the petition and the alleged violation would have continued and would have come to an end. We therefore ask the court to consider granting us a conservative order, and even if it is not compelled to stop the exercise altogether, it can stop the first respondent from forwarding and from certifying the signatures and forwarding the bills, the Constitutional Amendment Bill 2020.
What already have reached by the continuing issue of the signatures?
All right, Mary. The IBC has admitted in its letter to the petitioner, dated the 21st of December 2020, that it does not have or does not maintain a database of specimen signatures of registered voters. Yet, my lord, it is supposed to verify those very same signatures. To that extent, IBC admitted in its own letter that it only maintains biographic and biometric data of registered voters. The Constitution does not require IBC to certify and verify biographic and biometric data, but signatures. In the absence of specimen signatures, then IBC is acting or is doing the verification exercise in a way that it only needs to explain us, because to the best of what we believe that whatever it is doing is a clear violation of Article 257(4) of the Constitution. Number two, the second and the third respondents are the bodies that are mandated under Article 94 of the Constitution to enact laws that provide regulatory framework for the exercise envisaged under Article 257(4) and 5 of the Constitution. To date, there is no such law, there is no such framework that has been enacted by the second and the third respondent. IBC, in its letter again by of 23rd December 2020, admitted that it had developed its own administrative procedures and regulations. Then the question arises, under what law has the IBC formulated regulations? The Statutory Instruments Act is very clear on how subsidiary registration regulations and guidelines are enacted. And in the absence of the governing law, then whatever regulations, guidelines, or administrative procedures IBC has developed are null and void, because they do not have any power involved. Basically, that's what you're saying, that in the absence of data of the specimen of signatures, in the absence of the regulatory framework, there exist lacunas, there exist gaps that ought to be filled by a law. And until that law has been put in place, until IBC has a framework on how it maintains and keeps specimen of signatures, then it cannot purport to carry out the function under Article 257, 4 and 5 of the Constitution. We would therefore ask, yes, Madam President.
Yes, Commander, proceed.
Yeah, my lord, the she has proved a violation, and that this court must proceed on the basis that a violation is taking place. Our position, which we have intimated in our application, is that first, this is the third time in the history of Constitution 2010 that an exercise like this is taking place. This exercise happened in 2014, and what was called Poa Kenya. This exercise happened again last year, in 2019, last year was one, and the one was called Mzigo. This is the third time it is being exercised. So the outrage that the court has been invited to does not exist. The IEBC has done this before, and the court should give leeway to IEBC to continue as it has done, and with a presumption that it could not have been breaking the law all the way from 2014, and the petitioners has never found it fit to come to court to stop. But secondly, my Lord, the exercise that is now being, whose orders are now being made to appear so urgent, started 2 months ago, started in December. The court has not been told when it is supposed to end, but you will see from the documents that we have found, as you shall argue, that exercise, the last time it took place, took more than 5 months. I think it took about 6 months. So Madam Friend has not laid out why she needs an order today and cannot wait even up to next week for the IEBC to talk. And also, by law, the court has not been told that a similar order to stop this exercise was sought in a court of equal jurisdiction as this one. And we have put that order on pages 70 to 71, by law of our manuals, which very clearly the court, Justice Jairus Na, said that he would not stop that exercise. I would request my Lord to not accept this parental action without proper submissions being made before this court.
You said the order is in page
70 and 71 of our manual. There's a ruling on the letterhead of the judiciary.
Yes, it's directly to which particular.
After order number 4, by law, on page 17,
Yes.
you will see after order number 4 a sentence that says, leave is hereby granted to the applicant to file a substantive motion for the foregoing orders. And then the court says the prayer for leave to operate as a stay of any action by the respondents in processing the collection of signatures for the building bridges initiatives is refused. However, in order to expedite the hearing and determination, I hereby, and then the court went on to allow an expeditious hearing. In this case, we are, apart from the fact that our submission is that the court should be worried not being invited to issue an order in conflict with another court, especially not substantive arguments. I think the invitation is that, which your Lord had said, was that your Lord wanted to issue an order to all the parties to enter appearance, to file all the substantive submissions on this matter, and we come back again, which, my Lord, is to me the most, it's the most justicious thing to do in the circumstances. All that my learned friend is seeking is an order for whose she has not proved any damage that is going to happen within the next 10 days of this. And I am sorry, but to me, all she's going to walk away if she were to be given that order is a political point. they not have protected anyone from any damage. And we, on our part, are ready to comply with the directions of this court of a speedy hearing. We are ready to come back next week, any day that my lordship will order for a substantive hearing of this matter. And I believe in your order, so will all the other petitions.
All right.
That is my matter.
Thank you.
My Lord, I just a quick factual correction before you pen your ruling in the matter. The order that will be referred to at page 70 that was issued by Honorable your brother Justice Kanyama was in relation to BBI, that is interested parties, collection of signatures. It never attacked or do not base the arguments that we are basing, the grounds that we are basing. It did not bring in the constitutional power that we have brought in. It did not seek to stop the verification and certification of the signatures, rather than the collection of signatures. And it was based on different grounds altogether. Number two, the issue about that the exercise would take 5 or 6 months from today, those are submissions from the bar. I say so because my Reverend Senior is not representing IEBC. It is only the first respondent that can be able to ascertain and tell this court how long this process of certification and verification of signatures will take place. And I don't think my Reverend Senior is representing IEBC in the matter, rather than the interested party. The last issue, the fact that my client or the petitioner did not challenge IEBC actions during the Okoa, Kenya, and Punguza Mzigo BBI, constitutional amendment processes, does not mean that IEBC was acting in accordance with the Constitution and that it is stopped now the petitioner from alleging a violation of the Constitution. The petitioner's interest is only to ensure that the processes that are being undertaken in amending the Constitution are within the constitutional powers of the constitutional bodies, and they are doing it in accordance with the provision of the Constitution. It does not have any political interest. It is not in any way associated with any political party or advances in this country. And lastly, I would like to emphasize that this court has powers under Article 23(3) of the Constitution to grant a conservatory order to preserve the subject matter of litigation pending the outcome of the litigation. But if the verification and certification exercise being undertaken by the first respondent is completed, then the entire petition will be rendered nugatory. There will be nothing subject to litigate, and that exercise in this court shall be an academic exercise. In essence, therefore, my Lord, a conservatory order is important in this matter so as to keep the subject matter in situ pending the determination. Very well, we don't know how far the exercise has gone because it's only the IEBC that can be able to tell us that. Unfortunately, they are not here. So we would then propose that the best order to conserve the subject matter in our view would be to stop the IEBC from certifying and verifying and forwarding the bill to the county assembly.
My Lord, if I am allowed, I wish to state one thing that my learned friend has misled the court about, because if you might not want to read the ruling, the prayers that were being sought against the representatives, an order of prohibition to restrain the chairperson of IEBC from receiving the collected signatures. Prayer number 2 was an order of prohibition to restrain the chairman of IEBC from commencing any verification of the collected signatures. And the third order was an order of prohibition to restrain the first respondent from holding any referenda. So all the issues that my learned friend has placed before your lordship have been before another court, and the court was of the view that it did not merit a stay.
My right again, what were the grounds that application was based on? The orders of prohibition could not have been issued at an ex parte stage or at interrogatory stage. We don't have a judgment of any court. What we have is a ruling that sought correction of signatures. Order 4, the one that we referred to my word this morning, is very clear. It refused the processing and the correction of signatures. Have not seen anywhere in the ruling that was given any of the matters that my learned seniors alluded to this morning.
Thank you.
Thank you, Margaret. And the very last point I want to say is that the petitioner was not aware about the existence of these other matters that are in Nairobi. The petitioner is a human rights body based in Mombasa, and that's why it brought the petition within the jurisdiction where it ordinarily carries out its work, that is Mombasa County, Mombasa High Court. So it cannot be said that it mysteriously chose not to involve or to divert the information about the existence of other court matters. It's not a party to those matters, and it was not aware about the existence of those other matters. That is on my word. Thank you.
Commission, just one correction. The last submissions are coming from the bar. There is no affidavit to that effect, so that the last submissions by counsel. That's all.
Submissions will all come, but we have different chambers where we place them now at 9. So, but it doesn't cause any harm here. I'll put the note there down. This is my brief ruling on the matter. I have considered the submissions of the parties. In my view, the issues raised in the petition and the petitioner's application are very public in nature and are grave constitutional issues, especially at this time in our constitutional dispensation. There are issues which demand that the respondents herein be heard before an order can issue. However, it appears that despite the fact that the application and petition was served upon the respondents have failed or neglected to come to court. In that regard, and for the purposes of reaching an informed decision in this matter, the respondents must be compelled and are hereby compelled to enter appearance and either agree with the petitioner or to defend the same. In that regard, I make the following orders. 1. The respondents in this matter, the IEBC, the Speaker of the Senate, and the Speaker of the National Assembly are hereby compelled by this court to enter appearance and either defend or agree to the petition. This must be done within the next 4 days. The second order is that this court declines to grant interim conservatory orders as praised by the petitioners on the basis that the IEBC position needs to be heard before any such order can issue. And third, the petitioner's application and the remaining part of the interested parties' application can be heard later on 25th of January 2021.
Most of the